So this is time for Anjali Balagopal. Let me introduce her a little bit. Anjali is heading the intellectual property practice for Infosys. She is responsible for all the legal and strategic issues relating to the licensing, open source, patenting, trademark and copyright matters, including prosecution and compliance with respect to all intellectual property. During her 11 years with Infosys, Anjali has held several leadership roles within its legal department, including heading the contracts practice for North America, corporate compliance, and managing legal matters for Japan and Southeast Asia. She holds a law degree from IIPLA and is licensed to practice law in India and as a corporate counsel in California. She is currently based in Bangalore. The floor is yours.
Thank you, Irmak, for that lovely introduction, and good morning to all of you. It's great to be here in Dubai in this amazing forum, and the sessions so far have been very interesting, and we hope with our esteemed panel to make this another interesting session for you, and thank you, Nadeem, for that interesting discussion as well. So given that we're going to talk about M&A and the various IP issues around it, we hope to cover a lot of the various factors around IP, the due diligence, the pre as well as post integration of an M&A transaction, and the impact that IP has. I am coming from Infosys, which is a software services and a technology company, so I hope to bring some of that perspective as well to the table today. And I'll get started with what we're covering today. Essentially, M&A, talking a little about M&A on an inorganic path to growth, wherein IP assets, the acquisition of IP assets is extremely important. The business enterprise and value that IP brings, intellectual property being intangible assets and the value that they bring. I'll cover a prime part of the discussion agenda will be around due diligence, some of the illustrative examples that showcase how important the due diligence is in an IP acquisition, and some of the systems and processes that need to go into, and more thought that needs to go into it while you acquire a company for its IP. And then post-integration closing, as I said, which is equally important, after you acquire the target company, whether it is an IP acquisition or not. So M&A is extremely complex, right? And it can be done for various reasons, whether it's for the skills of the people in the target company, it is the technology access that you have in the target company, the customer base, or the market access, whether it's the customers or the kind of skills that you bring to the market. One very important and increasingly important factor that we are seeing that businesses see today and business leaders are looking at is intellectual property, right? And it's not just becoming one of the things that you look at the back end, but increasingly looking at upfront. Because if you are looking at the business objectives of an acquisition, you have to look at what is coming with it. And I think the intangible assets like intellectual property have to be considered very, very carefully before we kind of move into deciding whether we want to buy the target company or not. Right. So like I said, a business, if it has a particular enterprise, has certain value. It could be financed either by a share equity or an asset acquisition. It could be a public company or a private company. It could be a collaboration through a joint venture, or it could even be acquisition of in-licensing IP or out-licensing. But all of these factors has one thing common, which is the intangible assets, whether they are trademarks, patents, goodwill, confidential information, you're looking at trade secrets. All of these totally comprise of the intangible assets that not only have to be looked at in terms of what value they bring in when you acquire the company, but also how that can be a source of revenue going forward. So therefore, all these, whether the transaction is any kind, the importance of intellectual property is extremely interesting to kind of see how it kind of unfolds into the decision making of the acquisition as well as post the acquisition. So like I said earlier, we have to focus very, very importantly on the business objectives of why we're acquiring a certain company or why a target company is being considered. And then you have to assess what importance the IP brings to the table, right? And it could be different categories of IP that one could be looking at, and which we'll just go into the next slide. So while IP is not the only factor, it is an extremely essential factor, and I think that's what we've been saying, in this panel discussion that we want to kind of highlight. There are various kinds of IPs, which is patents, trademarks, copyrights, trade secrets, domain names. With the social media onset, there are so many other kind of, subcategories that fall under intellectual property that need to be looked at and determined of how important they are in terms of the value they bring in, how they will generate revenue, and what is the lifespan of those assets and what is the value during the lifespan of those assets, so that it can be integrated into the decision making of the acquisition. So while copyrights and trademarks do not need a mandatory registration, they would typically be unregistered intellectual property. There are various factors that go into determining the asset and the value. Patents and domain names can be verified at the relevant registries, as Nadeem also just pointed out, very specific to certain emerging markets. But every regulatory and every jurisdiction has its various registrations and various regulatory requirements that need to be looked into. And trade secrets are best addressed contractually. As we know, confidential information constitutes a very important part of any company's information that you're taking over or acquiring. So one has to look into the contracts for this particular category of intellectual property. While patents are typically most considered and most important, I think we are also kind of moving from that, wherein all the different types of IPs are important in the business architecture. So while you have to kind of look at what value an IP asset brings, what value a patent brings, and there are various, I think, thought processes on this among industry experts, whether you can constitute, whether you can present a certain significant value, a monetary value to a patent. I think that, again, is a discussion that can be debated on, among various thought processes on how you can monetize. But I think more importantly, you have to understand what was the purpose of that particular intellectual property, what is the purpose of that portfolio to the target company, and does that purpose align with your objective, right? So if you're looking at a patent portfolio for that matter, it could be have constituted for a defensive mechanism or an offensive mechanism. And the thought that the business leaders, the management has to think through when acquiring the particular portfolio is what value that is bringing to you, right? And along with that comes in various decisions on how you want to use that particular portfolio. For example, if it's a patent portfolio. So moving on, it brings me to one of the areas that I'd like to kind of focus on is on due diligence. It's an extremely important practice in any M&A, right? And the type of attention involved in vetting documents, vetting portfolios, vetting contracts is extremely necessary, and it is best done early on in the process, because like any other diligence, intellectual property diligence can also take a very long time and may be pushed to the back end, because at times it is not considered as necessary as the other areas of diligence. But I think, like my colleague was saying earlier as well, it has to be handled up front. It has to be determined in the beginning as to why you are acquiring, why you are interested in the intellectual property assets of this particular target company, because there are so many factors that go into it, like we'll just go through now. But the idea is that if you do not like what you're seeing in the beginning, it's better not to get into the process. So which is why, it's how much ever you stress it, is extremely important that the IP diligence is also done along with the rest of the diligence. And these are the various ways that, or at least the various assessments that should be done at the time of the diligence. And like for any particular diligence in an M&A transaction, there is an online data room where one needs to make sure that your IP checklist gets confirmed. So every organization, I think, while taking over a company, your attorneys, your advisors, your financiers will advise you on what is important to look at. Similarly, you must have your in-house IP counsels, your teams, as well as your external attorneys putting together that checklist in terms of what is that you want to look at in terms of what are the IP assets, in terms of the ownership rights. I think it's extremely important when you're acquiring something, that the company has the necessary ownership rights to transfer to you. Are there any licenses or encumbrances on the IP? We heard a lot about infringement analysis and FTO earlier this morning, which is extremely important to understand if those assessments have been done by the target company, and you need to have access to all of those opinions and analysis to make your own sound decision on whether that IP has the necessary IP hygiene and ownership checks done in order to make sure that you're not infringing a third party's intellectual property rights. The quality of IP is also extremely important. When coming from my experience, if I talk about the software sector, there are various components that kind of constitute a software. And, with the open source evangelism, spreading the use of open source is extremely high. Third-party software usage, not everything might be proprietary. So you have to look into what constitutes in the software, right? And if there is open source or there is third-party software, one important thing to understand is the target company willing to share those, information with you? Are they willing to scan their source code that constitutes software with the company that is buying them to ensure that, the company is comfortable with what you're actually taking on? Like any other area, like I said, it's important when you're acquiring software, what that software constitutes, so that you are not taking on encumbrances or any kind of infringements or any kind of impending threats of litigation while acquiring that software. So that's extremely important to understand. Along with sometimes, software deals or IP deals, is also important to understand what is the kind of access you're getting to the people, right? Again, going back to the tech sector, support is very important for a software. So if you're acquiring a very niche product, it's important that you have the necessary support, whether it is software related, whether it's people related, you have the necessary skills to actually maintain that software for your clients. So all of this is something that should be and these are, I think, very high level pointers. We can go into more details if required, but the question answer session, but I think the idea is that you have a necessary checklist, you have the necessary access to the documentation, to the software, to the information that is related to the intellectual property, whether it is contracts, whether it is regulatory filings, whether there are litigations or licenses that impact that particular intellectual property, and you have all that information in order to make the necessary decision. So I think just going back to some examples here that I'm sure a lot of you might have heard of, and these are really two examples from a buyer as well as a seller's perspective. I think the first one, as Nadeem also was talking about, Volkswagen, acquiring Rolls-Royce. This was back in 1998, where this is a case where inadequate due diligence could lead to, unavailability of information of the usage rights of a particular IP asset. In this case, it was the Rolls-Royce mark itself, which were pre-owned by BMW. And at that point of time, the unavailability of the information or an inadequate due diligence cost a lot of money in the future for Volkswagen to kind of get the necessary rights. The second example that I'd like to kind of highlight here is Daiichi Sankyo's acquisition of Ranbaxy. The due diligence, while it was conducted by the buyer, there were certain facts which were withheld by the Ranbaxy promoters at that point of time. So this is a situation of, completely opposite, where while the due diligence is done, but because information is withheld, or adequate diligence probably was not conducted to get the necessary information, there was a situation where it again led to a dispute, and then companies have to shell out a lot of money. You have to go through the whole turmoil of an arbitration or a litigation. In that case, it was an arbitration, where finally the promoters were ordered to pay us huge penalty for concealing information during the diligence. So again, I think the idea here is to kind of highlight how important it is, and not to kind of leave this at the back burner, but to make sure upfront you understand what you're getting if intellectual property is an important part of the acquisition. So I'll talk about post-integration, which is really, post-acquisition, wherein it's important as much as it is pre-acquisition to have a sound plan in terms of what you want to look for and what you want to kind of have in terms of a checklist. It's also extremely important to have a very, very robust post-integration plan, because, every company has its own way of functioning, and when you're acquiring another company, you have to ensure that you integrate all functions, all areas seamlessly. So whether it's a people acquisition, whether it is skills, whether it is assets. Similarly, for intellectual property, I think there are various policies and processes that each company has on usage of intellectual property, on compliance, whether it's open source. So it's essential that while you integrate, you seamlessly also integrate these policies and processes with the target company. At times, the target companies are smaller companies, smaller units, startups, which might not have that very advanced sort of system and policy and practice in place. But it's important to kind of understand how you want to kind of integrate. So you have the setup to have the post-integration done. Coming from Infosys, my experience in the acquisitions we've done in the recent past on software, I think this is one of the biggest challenges we face. While you have everything set up for pre-acquisition, I think it's post-integration wherein you face challenges, because at times, the companies or the software companies that you're acquiring are fairly small, who do not have these necessary practices in place. While it's being done, you might not have it documented, you might not have a a person to deal with patents. You might not know who's filing your patents or which registry, because they're just a small outfit. So at times that these smaller things that you kind of tend to overlook in a big corporate becomes extremely important to understand and integrate and educate as well, in terms of post-acquisition. Similarly, there are project management and systems and infrastructure set up for managing your portfolio, managing your litigation, managing your reporting requirements depending on where you are located and which regulations apply to you. So it's extremely important again to kind of ensure that the intellectual property assets that you have acquired, you have all the necessary information in terms of their own infrastructure and reporting, and you continue to do so without having to kind of face any sort of blocks or gaps in that process as well. Similarly, on compliance and risk, I think we spoke about litigation and third-party infringement and open source infringement arising because of lack of information or lack of diligence. It's extremely important that these are integrated well into your systems and processes, so that you continue kind of ensuring that there is clear policies that are set out to ensure that there are usage scenarios set out. A lot of time it happens that a smaller company that you're acquiring might be able to manage their own practices in the way they were doing, but as soon as they come into a bigger environment, a larger environment, an environment of a company which is extremely regulated, there are various factors that you have to kind of then set or constitute in place. So I think that's important, So like I said, policy and process integration, systems, compliance and integration, all of this are very, very closely knit and should be kind of kept in mind and have a clear plan in mind for even post-integration, where I think IP councils, the IP team should be extremely involved in, along with the M&A team. So that's all I had. I think just to kind of sum up and conclude, I think one important thing that we all kind of, I think, face is with intellectual property, it's always about maximizing the value of intellectual property for your organization, whatever the strategy be. So I think along with an acquisition and a merger, that has to kind of stay on in the mind, so that you minimize deficiencies in all the ancillary reporting and processes, but you maximize the value of IP in line with the objectives of the acquisition for the company. Thank you.